part of the delay is in relation to the faith and trust that ordinary citizens have reposed in the ability of judiciary as an institution to deliver justice. To what extent technology can enable that. We are, of course, in a very extraordinary situation during the global pandemic when courts across the country, particularly high courts and Supreme Court, have gone online. The real question is to what extent post-pandemic world and India would see the use of technology in the manner that is being used. If before pandemic, if anybody had even asked that would the Supreme Court and the high courts will do hearings in the way they have done in the last 1 year or so, it would be unbelievable. But then it also raises issues of the larger issues of access to justice. To what extent lower courts in India and courts across district courts are we having the kind of bandwidth? For example, in my own field, in the field of higher education and legal education, the reality is as follows. And this is not very different from the situation in the administration of justice as well. While we as a university completely went virtual, our students and we are all somewhat privileged that we never interrupted our academic session since March 2020. And that was because of the fact that we could create a virtual online platform and work with our students and faculty. But there is enough data now to say that nearly 12 to 15% of Indian households have three things, which Wi-Fi, relatively uninterrupted Wi-Fi, second, relatively uninterrupted electricity, and then equipment. All these three things are critical for pursuing online education. And you can imagine then the kind of disparities that prevail. If I were to bring that analogy into the administration of justice process, while the High Courts and Supreme Court have been doing what they did all this while, the question is how we can scale it up and how we can reach out to the nook and corner of India and to what extent that can help us in the larger issue of administration of justice, but also providing access to justice. Now, I'm going to spend time on two issues since I have only 10 minutes, and both of which are very dear to me. One is the question of judicial appointments. The other is the question of judicial overreach itself, which is talked about in various contexts. Let me start with the issue of overreach itself. So there has been a lot of discussions and debates surrounding to what extent judiciary can, let's say, involve itself in issues relating to policy. Several years ago, the then finance minister, Mr. Arun Jaitley, observed that, and I quote, judicial review is the legitimate domain of the judiciary, but then a Lakshman Rekha has to be drawn by all the institutions themselves. Lakshman Rekha is very vital, unquote. Because he further added that executive decisions are to be taken by the executive and not the judiciary. Now, these are not observations that have been uniquely brought by people outside the judiciary. Many judges have off and on brought this element to the discussion. The question then is, and most members of judiciary will not disagree with the fact that the separation of powers principle articulated by Mr. Jaitley is real and important. But the big challenge is in relation to where the Lakshman Rekha should be drawn. Historically, the judiciary has been progressive and inclusive in interpreting various provisions of the Constitution to uphold justice. The evolution of public interest litigation, liberal and progressive interpretation of standing rules, expansive interpretation of fundamental rights and directive principles of state policy, invoking the writ of continuing mandamus, recognition of substantive and procedural due process as tools to fulfill the vision of constitutionalism. All these aspects have been widely appreciated. This is indeed the strength of Indian judiciary, led by the Supreme Court, but also high courts across the country. Now, given this context, the debates on the relationship between judiciary, executive, and legislature are critical, and I'm glad that this forum can also provide the opportunity. The judiciary, I believe, is facing twin challenges. First, it is responding to the enormous challenges of delays and dealing with delay and pendency. Second, it is also responding to the challenge of meeting social expectations and civil society demands on judicial intervention in almost every aspect of the governmental decision-making process. And we are, of course, familiar with the fact that arbitrariness and violations of constitutional principles are at the heart of appeals for justice that is coming through. I believe that the following principles can inform us of what is at stake and enable institutions of government to exercise their powers in an effective manner, respecting the separation of powers doctrine. First, law, policy, and judicial intervention. The separation of powers doctrine is about the legislature having the prerogative of making laws, the executive being entrusted with the responsibility of implementing laws, and the judiciary vested with legal and constitutional powers to adjudicate disputes and review both legislation and executive action for their compliance with the Constitution. Now, of course, theoretically, this sounds perfect in terms of each institution operating within its domain. But in reality, this theoretical framework of separation of powers is constantly under challenge, and the navigation across these abilities of these institutions to exercise the powers does come into question. The judiciary needs to evolve a robust set of principles on the basis of which, on its own, differentiates its interventions on matters which are not related to law and are actually policy questions. This is a continuous effort. I believe that elected governments are best suited to make policy choices. They are better placed to determine the suitability of particular policy choices. But the judiciary must intervene if any or all of these powers are arbitrarily exercised. It is not all that difficult to tell a priori what is law and what is policy. But in the context of how these powers exercise, there is a constant tussle. The real difficulty arises when enforcement of law and implementation of policy results in a clear violation of fundamental rights enshrined in the Constitution. Second, constitutional norms and institutional limitations. The judiciary is vested with the obligation to ensure that all the wings of the government follow constitutional norms. Our courts have intervened in matters that appear at first blush to be substantive questions of public policy as opposed to law. In such matters, the judiciary interprets issues from the standpoint of upholding rights and values of justice. The judiciary must recognize that there are inherent limitations to the exercise of judicial powers when it comes to its policy questions. We are familiar with the landmark case Bommai versus Union of India. The Supreme Court, in relation to the exercise of the emergency powers in Article 356, observed, and I quote, "The opinion which the president would form on the basis of the governor's report or otherwise would be based on his political judgment. The temptation to delve into the president's satisfaction may be great, but the courts would be well advised to resist the temptations for want of judicially manageable standards," unquote. So the key words are judicially manageable standards. What are these judicially manageable standards, and at what point of time they come into tussle between the identification of those standards and the natural expectation of the courts to intervene. Third, judicial restraint and executive accountability. The judiciary must show much more restraint when it is asked to decide upon questions of policy. Determining correctly what properly constitutes a question of policy calls for competencies that the judiciary sometimes may not possess. There are several instances where even the Supreme Court of India may have arguably crossed the Lakshman Rekha. In 2012, for example, the court ordered interlinking of rivers. This was criticized as a disquieting judgment because it encroached into the executive domain, and many judges have themselves said about it. Even if a citizen's right to water is a fundamental right that gives the Supreme Court some rationale to review executive decisions, to order the interlinking of rivers in the face of clear executive unwillingness to do so, supported by some expert opinions, is an example of the court possibly overstepping its boundaries and getting into the domain of policy making. However, there have been other judgments, including a 2013 order directing the creation of an independent civil servants board, or for that matter, the Vishaka judgment itself. These things were positively received as it undid the injustice done to a civil servant, or in the case of Vishaka, creating a framework for addressing sexual harassment. So the question then is, there is the need for judiciary to exercise self-restraint in policy matters which are not necessarily violating fundamental rights, because it lacks the wherewithal and competencies to grasp all the ramifications of policy choices. A decision of the Supreme Court is the law of the land. When courts decide what policies should be legally mandated, it will need revision judgments to change those policies in the public interest. Judicial calibration of policies is indeed unwise, and one needs to be conscious of it. Let me quickly move to the next part of what I wanted to briefly reflect on, which is about the judicial appointments itself. Now, I was somebody who argued before, when the NJAC was passed, the law was passed. I argued even before the judgment that was unconstitutional, and I believe that the Supreme Court of India did the right thing by declaring it as unconstitutional. The question then is, what is going to be the future, and how do we fashion a future institutional mechanism? Now, there is little doubt that the collegiate system for appointing judges, the high courts in the country, has been fraught with significant problems, including judges to the Supreme Court. This landmark judgment had provided an opportunity for the court to be both self-critical and reflective in addressing the most important challenge of ensuring greater transparency and integrity in the appointment of judges. Now, transparency can be promoted by making the process of appointment of judges more democratic in nature. Complete lack of transparency was one of the significant drawbacks of the collegiate system. Nobody outside the system knew as to why some judges were appointed and some others were rejected. And I have had innumerable conversations with both current and former judges in the Supreme Court and other high courts, and they have, that view has been resonated from them as well. So everybody is in agreement that the reform of the collegium system is needed. I have argued, and I would like to say, that there should be 5 principles on the basis of which this reform needs to be taken while reimagining a new process for appointment of judges. First, transparency. The most persuasive criticism of the collegium system has been the fact that appointment of judges has been secretive, with no information available to anybody outside the collegium about the process leading to the appointment of judges. Any effort to reform the existing system should recognize the need for transparency in every stage of the appointment process. Without a transparent process of the appointment of judges, the collegium system will not have the credibility and the legitimacy for it to be accepted by all stakeholders within the legal system. Transparency will not be established merely by stating that the members of the collegium will act in a transparent manner. It will have to be demonstrated by the process that the judiciary adopts in the selection of judges. Second, and this is a very important theme, and I want to apologize to all the viewers that this is an entire panel full of men. All of us who are in this panel, including myself, we are men. We really need to focus on diversity in all its forms and manifestations. The second aspect of the judicial reform is that the future of the collegiate system and its credibility will depend upon diversity. Its steps that it takes to infuse diversity and establish it as the norm and practice for the appointment of judges. The lack of gender diversity in the higher judiciary in India is a matter of critical concern and deserves urgent attention. It took nearly 40 years for the Supreme Court of India to appoint its first woman judge. The next 25 years was followed by the appointment of 4 judges to the Supreme Court, and for the first time in its institutional history, there were 2 women judges serving in the court a few years ago. In a reply to a question that was raised in Parliament a few years ago, it was observed by the Ministry of Women and Child Development that the information provided by the Department of Justice, Ministry of Law, indicated that as of 10th July 2009, out of a total of nearly 650 judges in the Supreme Court and High Courts, there were 51 female judges. This represents a meager 8% of the judges in the High Court and Supreme Court who are women. It is not enough to assume that any transparent process will lead to the appointment of meritorious women as judges in the higher judiciary. I believe the following 5-step process simply to infuse diversity is needed. First, the existing judicial colloquium should have at least 1 woman judge, regardless of seniority, who will be involved in all decisions for the appointment of judges to the High Courts and Supreme Court. Second, tangible efforts need to be taken for the promotion of existing women judges in the High Courts to be Chief Justice of other High Courts that can fast-track the process of consideration so that they can be appointed to the Supreme Court in the years to come. Three, the existing practice of examining the candidature of judges for appointment as judges of high courts or elevation to Supreme Court only after attaining a particular age needs to be reconsidered so that more women lawyers could be appointed as judges of the high court sooner than later, so that they have greater seniority to serve in the Supreme Court in the years to come. Fourth, the Chief Justice of India may consider constituting a task force for promoting gender diversity in higher judiciary with at least 50% of its members as women judges, lawyers, and academics to make proposals that will lead to the evolution of a gender diverse higher judiciary in India. And five, law schools across the country should take efforts to create a more gender diverse student body and faculty, inspiring more women law students to seek careers in the judiciary. I'm happy to report that over 50% of our faculty members in Jindal Global Law School are women, and 50% of our students are also women. These are small steps that we need to take. The third aspect of the reform of the collegiate system is about competence. The competence of individuals to be appointed judges needs to be clearly established. This is a very critical and central aspect of transparency. While the subjectivity in any aspect of selection is indeed inescapable, this should not discourage us from establishing certain threshold standards that will be taken into account for measuring competencies. In fact, in this day and age, when every exercise of power by every authority is subject to the test of arbitrariness, there is no reason why the judiciary as an institution should be also imposing on itself a high standard to avoid any criticism of arbitrary excess of powers. One of the ways by which the risks of the arbitrary excess of powers in the process of appointment of judges is in relation to the determination of the criteria for selection. There are a number of measurable standards that could be evolved for determining competencies, for assessing the suitability of individuals to be appointed as judges. The fourth, which I think is absolutely critical, which is about integrity. One of the most important aspects of judiciary as an institution is the bedrock of unimpeachable integrity that is expected out of judges. While it is essential that all public authorities are persons of integrity and rectitude, the public expectation when it comes to judges surpasses all other institutions. This means that integrity becomes a significant aspect to be evaluated in the selection process for the appointment of judges. The collegiate system is well suited to determine whether the candidature under consideration would fulfill the criteria of unimpeachable integrity. The strength of judiciary as an institution is the fact that it is the guardian of the Constitution. It is the only authority that is vested with power to interpret the Constitution and to determine whether all institutions have acted in consonance with the Constitution. These are extraordinary powers, and hence the responsibility of the collegium becomes higher and sacrosanct while selecting individuals who will be responsible to exercise these extraordinary powers. Fifth is conflict of interest. Now, a lot has been said and written about it. The issue of conflict of interest needs to be thoroughly established in the process of selection of judges. The collegium has been fraught with serious allegations of different types of alleged conflict of interest among the members of the collegium and the individuals they've selected to become judges of the high courts and the Supreme Court. There's an urgent need for the collegium to formulate a detailed set of rules and regulations that will govern the determination of conflict of interest among the members of the collegium who are involved in the selection of judges. For example, some of the issues that have come to the forefront in determining a potential conflict of interest could be whether judges from a particular high court or state should be involved in the selection of other judges from that state or high court. If so, what precautionary steps will be taken by the collegium to avoid or prevent biases, prejudices, or other forms of preferences based on friendship or familiarity in the selection of judges. Another issue of conflict of interest would be to what extent lawyers who have worked as juniors in particular chambers who have become judges in later years could be involved in the selection of juniors from those lawyers' chambers to be selected as judges. I'm not saying one should not be selected. I'm saying we need to be conscious of the process itself. So the new appointment process within collegium should have the criteria for selection of judges, which is absolutely critical. They should have a very solid process, an application process, and a rigorous scrutiny. In fact, there's a need for an application process which includes a nomination system as well. In some ways, both these processes will ensure that the widest possible pool of candidates is available for the selection of judges. There's also a need for more rigorous scrutiny of the application so that the candidates are assessed on the basis of criteria that were formulated. There's also a need to ensure procedural fairness by ensuring that the meetings of the collegium are conducted in a fair and transparent manner with a detailed account of the proceedings of the deliberations. There is no reason for the judges not being able to record the reasons for the selection or non-selection of individual candidates for the appointment as a judge. This needs to become part of the process to ensure both transparency and accountability and procedural fairness in the selection of judges. The third reform is there should be a permanent institutional mechanism within the Supreme Court. There's an urgent need to establish a separate and independent institutional mechanism within the Supreme Court, which will exclusively serve as the administrative office for dealing with all matters relating to judicial appointments. This is one of the most important steps that the court ought to take to ensure both transparency and procedural fairness. What is needed is an Office of Judicial Appointments, which will have its own staff, headed by a director and other staff members, whose main responsibility is to process all applications for the review of members of the collegium. The processing of applications is not a routine mechanism, but rather a comprehensive and rigorous mechanism that will involve an entire administrative system to ensure that all information is duly collected and collated for the examination of the members of the collegium. One of the major challenges in the collegium system is also about the lack of time and attention given by the judges to the appointment process, along with their primary duties and responsibilities of hearing cases, adjudicating matters, and writing judgments. Indian judges work very hard, harder than any other counterpart anywhere in the world. That means there is so little time for the application of mind and a rigorous scrutiny when it comes to the appointment judges, and they need a strong secretarial support. Establishing a separate and independent body for the appointment judges, which will report to the collegium, will be one of the most important governance reforms that the judiciary can initiate towards promoting transparency. Lastly, the credibility of the judiciary is indeed at stake, and it has to get its act together with a view to addressing some of the central questions that all stakeholders in the justice system are asking. What steps will the judiciary take with a view to reforming the existing collegium system? What will the Supreme Court do to ensure that the collegium system is significantly transformed with a view to infusing transparency and procedural fairness in the selection of judges to the high courts and the Supreme Court? How will the judiciary restore the faith of all actors in the legal system that judicial appointments will take place through a selection process that will withstand legal and constitutional scrutiny? These are questions that ought to be asked by members of the collegium as much as by other judges of the Supreme Court and academics and lawyers and judges who are present here, as we work towards the restoration of the credibility of the judiciary as an institution, including its appointment process. I know I've taken a little more time than what I wanted, but thank you very much for this opportunity. And I look forward to being part of this wonderful panel discussion with some outstanding legal minds who are present here. Thank you very much.
Thank you very much, Professor Raj, for this great enlightening session and giving very practical insights. Really grateful to you. And now I'll be requesting Dr. Surana to lead from here as the moderator of this whole session. Over to you, Dr. Surana. Thank you.
Thank you, Professor. A very warm welcome to our esteemed panelists and to the numerous participants in this webinar from all over the country. At the outset, I would like to convey appreciation to our partner academic institution, the Jindal Global Law School. Within a short period of 10 years, this institution has risen to the top position among Indian law schools when it comes to research and academic scholarship. This is the third round of the Surana and Surana Knowledge Series, and I am really grateful to my good friend, Professor Raj Kumar, for joining us at short notice and giving us his detailed insights into two very important aspects of judicial reforms, namely judicial overreach and judicial appointments. The idea of this series of webinars is to identify a problem and, more importantly, to identify possible solutions. Now, regarding judicial reforms, I would like to quote Justice A.P. Shah, who in 2018 mentioned the judiciary needs immediate reforms on multiple fronts. The leaders of the bar ought to make more proactive steps towards introducing reforms in the judiciary, especially in transparency. Access to justice, he mentioned, was an inalienable fundamental right. We have 5 brilliant panelists who I would quickly introduce. Of course, Professor C. Rajkumar, we all know, he qualified from Delhi University, from Oxford, from Harvard. He taught law in Hong Kong for many years before coming back to India to start this fantastic university, the Jindal Global University. The second panelist is Dr. Justice Jayachandran, a product of the Madras Christian College and the Delhi University, a part-time professor of the Madras Law College, a specialist in labor and service matters during his law practice days, and a judge of the Madras High Court from 2005 to 2007. After his retirement, Justice Jayachandran completed his PhD on the very important topic relating to human rights of the marginalized sections in the unorganized sector in India, especially women and children. After retirement, Justice Jayachandran is also chairman of the Human Resources Committee of the Government of Pondicherry. Our next panelist is Mr. T.R. Gopalakrishnan, who worked with the Week magazine for over 35 years, of which he was an editor for 29 years. Mr. Gopalakrishnan left IIT Kanpur to pursue journalism in 1974. In his career, Professor Gopalakrishnan has covered a diverse range of topics and interviewed celebrities in India and overseas. Currently, he is the consulting editor of citizenmatters.in. We have another good friend and a prominent lawyer, Mr. Sanjay Pinto. He is an advocate, author, columnist, public speaker, and the former resident editor of NDTV 24/7. Sanjay and I are alumni of the Madras Law College and the Cornell Law School. Having known Sanjay since college days, in those days he was a national debate champion with more than 103 victories in debates.
Sanjay and I are alumni of Loyola College.
Yes. Our next panelist is Alok Prasanna Kumar, who is the co-founder of Vidhi Center for Legal Policy, Karnataka, specializing in judicial reforms, constitutional law, urban development, and technology. His writings have been published in many leading national publications such as the Hindu newspaper, Indian Express newspaper, Scroll, Quint, Economic and Political Weekly, among others. He holds a Bachelor's of Law from Nalsar, Hyderabad, and a BCL from Oxford University. Before starting the Vidhi Center, he practiced in the Supreme Court and the Delhi High Court in the office of Mr. Prasanna. So, without spending further time, I would like to jump straight into the topic. We don't have much time. The subject is very vast. We have decided, after consultation with all the panelists, that we will address 5 important areas under judicial reforms, namely corruption, delays, costs, judicial overreach, and technology. Mr. Rajkumar has already touched upon judicial appointments and overreach. So, to start with, I will quote Justice Krishna Iyer when we discuss corruption in judiciary. In 2011, Justice Krishna Iyer wrote an open letter where he mentions the judiciary is a sacred instrument with great powers to punish corruption. It is itself corrupt. Not a single corrupt judge has been caught or punished. Justice S.P. Bharucha, the former Chief Justice of India, famously gave an interview where he said 80% of Indian judges are not corrupt, thereby placing a question mark on 20% of the Indian judges. Transparency International, in its surveys as late as 2020, shows that 63% of Indian population perceives judiciary to be corrupt. There are several examples I can give, but I would like to place this question before the panelists. Perceptions of judicial corruption as well as very specific allegations of corruption starting from judges of the Supreme Court. Sanjay Pinto, what would you think about this concept, and what, in your opinion, would be two solutions?
Thank you, Vinod. I can only remember what Lord Denning had once pronounced in classic prose. He said, if you don't want your dirty linen to be washed in public, that is very simple. Please don't have dirty linen at all. As long as you have judges drawn from society, if society is corrupt, you cannot expect the judiciary to be class apart from the rest of society. So that's the reality that we have to accept. Secondly, you have the Contempt of Courts Act. And although it is meant to ensure that there is no undue interference in the administration of justice, that scandalous remarks are not, comments are not made against judges. You may assail a judgment, but you may not personally attack a judge. I think that will effectively ensure that any criticism of the judiciary is actually kept, it's like a chilling effect on criticism of the judiciary. I'm actually on the fence as far as the Contempt of Courts Act is concerned. I do believe that it is required to have a certain amount of deterrence. Otherwise, people will go, especially now with the social media, people will, the moment somebody loses a case, they will attribute motives to the judge. But I think there has to be some sort of a body. It has to come from within, introspection from within the administration, within the judiciary, to have, whenever there is a judgment that obviously goes against all canons of justice and fair play, where there's an internal mechanism to actually review that judgment if it is flagged by litigants or by a body of lawyers who are perhaps affected in this case. Unless we have that institutional mechanism, and unless the Contempt of Courts Act is not used as a sword rather than a shield, allegations of corruption will be confined to whispers in the corridor.
Sanjay, I would like to take off from that last line which you said, contempt of court and the judiciary. We have two recent examples. Prashant Bhushan was let off for contempt of court with ₹1 fine, whereas we have a comedian who went to jail. Alok, what do you think about this concept and this situation from a think tank perspective?
Alok, unmute yourself, Alok. The most important line of
so
the pandemic.
I'm sorry. I didn't realize I was muted. Very quickly, what I was saying was that let's not limit corruption to pure quid pro quo monetary corruption. That is the common sense perceptual understanding. But I think for the judiciary, the idea of corruption has to be a little wider, because we are not talking about punishing individual judges. We're talking about the reputation of the judiciary itself. And in this context, I like to quote one of the finest bits of research that I have seen in my life, which is this paper called Jobs for Justice by 3 scholars based in Singapore, Madhav Ane, Giovanni Ko, and Shubhankar Da. It's freely available. I would urge everyone to read it. Please just Google Jobs for Justice. They have shown, using rigorous econometric methods, using free publicly available data, how judges of the Supreme Court of India start favoring the government the closer they come to retirement. And I am simplifying their argument. It is actually very nuanced. It is very well made. And they very clearly point out that judges who were otherwise deciding cases on merit start favoring the central government, not just any government, central government in important cases closer to the date of their retirement. And the implication is obvious. We have done the research on this of about 100 or so judges that we saw in a given time period. We found that 70 had gotten a post-retirement position of some sort or the other. Now, it is not to say that all of them are corrupt. It is not to say that every judge who starts deciding cases in favor of government is necessarily corrupt. But we have to understand some of the structural features and how the institution is affected by it. So when we say corruption, it is not. I think we have to also be careful not to imagine this is like some human flaw in an individual. That is one part of it. But we also have to understand there is an institutional element to what we call corruption, and that is how it can make people perceive the judiciary worse. And that is where criticism of the judiciary is so important. Uh, Social media and like the coverage of this judiciary has, I think, the Contempt of Courts Act has honestly been rendered irrelevant. Going by the point that Mr. Sanjay Pinto just made, I think the Contempt of Courts Act has been made irrelevant every time the judiciary has tried to curb anyone from saying something about them on social media. The amount of criticism has increased tenfold. And I follow it every day. I think we have to completely rethink what the Contempt of Courts Act is supposed to do. I won't offer an immediate answer, but I just want to say that if the judiciary has to protect the reputation of the institution, it has to be tolerant of a lot more criticism, and it has to use the Contempt of Courts Act in a very different way, in a very different manner.
Alok, I will come back to you a little later.
Sure.
Regarding Contempt of Court Act and many other archaic old laws representing an old school of thought. But now I will go to Justice Jay Chandran. My lord, do you think this criticism that the judiciary is attracting, is it fair?
So you're muted.
So please unmute yourself, sir.
Yes.
Unfortunately, this aspect of corruption in the judiciary seems to be a reality. How much and in what manner it is prevalent is hard to find. We go by the people's perception, but also from what some of these judges had said about corruption in the judiciary. We have, I mean, I don't mind sharing a few names, like Justice Venkatramaiah, former CJR. We have been talking about corruption in the judiciary. Justice Barucha, as it was said, he said 20% of the judges in the judiciary are corrupt. But the problem is, even if one is said to be corrupt, we don't know which one is that. You know, just imagine the kind of fear that the people at large, the society will have. Once you know that there is a judge, we don't even know which judge it is. But once you know there is corruption, everybody seems to fear going to the court and getting their justice which is due to them. Like that, I can quote Justice Saldana of Karnataka High Court said 33%. Justice Markandeya Kajju himself, who was our Chief Justice earlier, he said he talked about corruption in the Supreme Court. Justice Chalameshwar did that. Justice M.N. Venkatachalaya said corruption in the Supreme Court. Justice B.R. Krishnaya, who we regard, we have the highest regard for him, made allegations against particular Chief Justice of India. Justice Verma, J.S. Verma had said, Justice, whole lot of issues. Now, recently, of course, we heard about the Justice Ramana, who against whom certain allegations had been made by Jagmohan Reddy, the present Chief Minister. Now, these are all allegations. You know, we find it. In fact, I was in the collegium for a substantial number of years, maybe I can say 2-3 years. We found it extremely difficult to find out, people who had absolute integrity. We had a lot of recommendations coming in from judges, from lawyers. In fact, it started like this because collegium system was mentioned about. We are supposed to be choosing people, keep watching them, over years. I've been there somehow involved in the judiciary and in the legal profession for nearly 40 years. So we keep watching people grow in the judiciary and then choose the best of them, then try to invite them to be a judge of the court. But these days, it is as though people have to make applications. They come up and say there are so many vacancies. Can I be considered? The whole process seems to have changed from what it was to what it is now. The other thing is there is a kind of a perception that based on religion, caste, and other factors, people have to be chosen. There should be some representation from a particular religion, from a particular caste, and things like that, which I'm not sure whether it is the right way to go about it. There could be meritorious candidates in all religions, castes, and groups. But then trying to give representation to a particular caste which is not represented, and things like that. These are some of those aspects which have to be considered by the collegium and which is being considered by the collegium. And I'm not sure whether that's the right thing to do. And probably the National Judicial Appointments Commission in JAC could have been given a chance to work for some time and see whether that was working better than the collegium system. I know for sure that the collegium system is not the perfect system, but that seems to be working all right. But with regard to the corruption in the judiciary, yes, especially there is a lot of allegations about corruption in the lower judiciary, and people's perception do matter. We are not able to pin down people with those allegations because allegations are made. We have the special cells in the High Court and other places where, for looking into these complaints. But then when we really go into the investigation part of it, we have the vigilance cells. When we go into the actual, aspect of the allegation, nobody comes forward to give sufficient evidence, either due to fear that they will, if they are lawyers, that they may lose their cases before the judge is concerned, or also, as you said rightly, you pointed out that contempt of court against whistleblowers. Prashant Bhushan's case was one of them. But also, we need to protect the fair name of the judges who are really good. Allegations can be just made just like that, because every case there will be one or two. Somebody is losing, so there can't be an allegation made against a judge for having lost the case.
If I may kindly interrupt, my lord, your lordship had mentioned that there are lots of allegations being made. Now, I have heard in the corridors of the Supreme Court that whenever names of probable candidates are referred to the High Court or the Supreme Court, the maximum number of anonymous complaints received is from the Madras High Court, and you have been a judge of the Madras High Court. Would you like to say something on that? And we would like to know from your perspective how the collegium considers such anonymous complaints.
See, that's why I say it's very difficult. In fact, you said till 2007, I was the judge from 2005 to 2017. And when even before a name goes to the Supreme Court, or even before a name is considered, there are many petitions which are coming in. We don't have the mechanism to check for sure as to whether this person's integrity is doubtful. We know, even lawyers, we know for many years, we know a lawyer from, say, 10 to 5, 10 in the morning till 5 in the evening. After 5 in the evening till 10 till the next morning, what he does, we don't have any mechanism to find out. It's very, very difficult. So what I would propose is, if you want to consider a name, then the whole process of selecting judges should start at least, if not 1 year, at least 6 months in advance. When vacancies are going to arise. You start checking the background of a person who you think can be considered to be a judge of a particular court. But that is not done. And then, yes.
My lord, recently the central government mentioned in the Supreme Court that the memorandum of procedure says you must start looking for replacements of a vacancy 6 months before the vacancy arises. But the courts have not followed it for more than 15-20 years.
One other aspect which I would like to mention here about this particular subject is many a times the top three judges are in the collegium. All right, the top three judges are the collegium. Many a times, all the three are from outside the state. I for sure see. I've seen during my tenure that at times the first four, top four are from outside. How do they know unless they get a feedback from the rest? In fact, Justice Kaju, when he recommended my name and along with 17 others, he had gone down to at least about 10 to 15 judges of the High Court about about the shortlisted names. He also went to a number of senior counsels to find out about these names, their integrity, their merit, etc. They can have a much wider investigation, much wider consultation before the names are shortlisted. Yes.
I would like to pause here for a moment. I would like to request the opinion of my friend Mr. Raj Kumar. As a law teacher, I mean, I heard you speak about the necessity for encouraging more and more diversity and more young lawyers to join the judiciary. What, as a law teacher, would be the steps you will take to achieve this?
Well, I think one of the things that we need to do, I mean, the heart of what Honorable Judge and all of us are discussing is how do you develop individuals with integrity and honesty and rectitude, and this is also about character development. And I must say that Vinod, I think it's a structural issue that as a society we need to address, because these are some very fundamental human values that cannot be necessarily taught in a school or even imbibed in a professional setting. I think there's something to be said about one's own upbringing, the kind of emphasis that one gives in society towards ethics and values. I think one of the big challenges, a larger issue that we have to address in our society, maybe other societies as well, is has greed has dominated all aspects of our thinking and worldview. A Harvard-based moral philosopher named Michael Sandel wrote a book a few years ago entitled "What Money Can't Buy: The Moral Limits of Markets." Should there be moral limits, and how do you ensure that? So the question of, I think it's important for us to recognize that, but then what we also should understand is, because of the fact that that's a long-term project where we need to, building ethics and values in society is a far more difficult thing, we need to rely on process. I mean, as a lawyer, I'm sure you will appreciate the fact that in law, what we have is essentially process, because we believe that if you can, ensure a transparent process, then we can hopefully address some of the issues of integrity that we are battling with.
Raj Kumar, I have a question. You spoke about the necessity for character development, and you quoted a Harvard law professor who mentioned what money cannot buy. I am reminded of a very senior bureaucrat who once spoke to me about training for the civil services. He said, and I quote him, "A vast majority of the people who pass out of the civil services training program are already addicted to expensive liquor. How do you expect them to be fair?" As an educationalist, what are your views?
Well, Vinod, I think this is a very serious problem in our society. If you remember, it's not just our society. I mean, I think we should. You remember the famous movie by name Wall Street? Michael Douglas, 3 decades ago, he in that movie there's a phrase he says, "Greed is good," and that used to be the mantra of Wall Street and the subprime mortgage crisis, and what we've seen from Enron to other scams around the world is part of a very serious, I think, moral and ethical challenge that has been affected and impacted the world at large. So I think it's absolutely critical for us to call it when it happens. There should be systemic and procedural safeguards against that. and we need to emphasize that constantly. And one of the things that we, as law schools, we place a lot of emphasis is that it's absolutely critical to maintain honesty and integrity in all our conduct. And I think a lot of it is also depends upon mentoring, for example. One of the things that particularly young people are observing what the others are doing. I remember many, junior lawyers who are now senior lawyers, when they work with, in the past, when they had worked with people like A.K. Venugopal and other distinguished seniors, they are constantly observing and they are imbibing those values. So one should not underestimate the ability of mentorship of a kind which happens in law school. So I always tell my own faculty that our students, you can tell our students whatever you like, but they are actually going to follow what you do. So what you do should be connected to what say. And I'll give you one very interesting anecdote. This is a very personal one. I have a young son. Some years ago, he's now in 12th standard, but some years ago, I work a lot from home, and I work a lot in the university and come home late in the evening. And when I come, he would be watching television. And I will tell him that, what are you doing? Every time you're watching television, why don't you go do some reading? And I would be slightly upset with him. And then I will go to my bedroom and change my clothes and start watching TV. And this I was regularly doing this. And then in one weekend when I was with him, I would talk about it, and I said, well, you keep telling me that I shouldn't watch TV, but that's what you do all the time. You come home and just watch TV. So I'm like, that made me think that it's just the behavioral aspect of it, that people are observing you, and regardless of how much ever emphasis you might give in your talks and lectures and seminars and workshops and even your own, judgments, ultimately people are going to follow or actually get imbibed by how you conduct yourself. And that's why, whether it is a judge or a senior lawyer or a law professor or others in society, including politicians, I dare say, people need to conduct themselves with integrity, because that's what others are observing.
You are very correct, Rajkumar. And now, and in today's glamorized societies, what is seen as being rewarded is often imbibed and repeated. I will next go to Alok before I go to Mr. Gopalakrishnan. We are speaking about judicial corruption. Alok, I know that you have some strong views on diversity and merit in judiciary. Do you think that making the judicial appointments more diverse will have a positive impact by bringing down corruption? Please. You must unmute, please.
I'll tell you an anecdote that I heard when I was practicing in the Supreme Court. And this is something that Justice Satasivam himself said when in open court. There was this case being, and he was in the Madras High Court, there was this case being argued between two groups of parties over certain trees in an agricultural land. Two well-paid senior advocates are going on and on about the law and the trees and everything. And Justice Sadasivam says, stop. Do you know what kind of trees you're talking about? They're like, these trees. Do you know these trees have male and female varieties? In the sense that even the trees have gender, and you can't separate the male and the female because they need to fertilize and they need to produce, and they produce fruits only on that basis. So do you realize how stupid your dispute is, trying to divide into male and female trees without knowing that the species of tree actually has gender? Now, he could say that because he came from an agricultural, rural background. And when I say diversity, I just don't mean that we have to have X number belonging to X caste, X number belonging to Y caste or Y religion or gender and so on. The reason why I say this is because judges today, whatever law, however we interpret it, it is all informed by how we see the world, right? All those tools of interpretation are only help us give it a certain set of reasons for what we think is intuitively just, right, wrong, and so on and so forth. Now, when you don't have a certain kind of life experience. Like, we have seen this and around the world. I'm not just giving this as an example only in India. Around the world, what they have found is that the quality of judgments, the quality of outcomes, the quality of decision making improves when there is diversity. And when I say diversity, I mean people coming from different backgrounds. Now, if we have, and again, no offense to anybody who fits this criteria, if we only have men belonging to upper caste whose parents were in the legal profession and who practiced only civil law in our high courts, we are not going to get the kind of, people are not going to have the kind of confidence in our judicial system when they see that, they don't even know what my life is like. They don't even know what our struggles are. They don't even know what our issues are. Now, we've had very empathetic, humane people who might also meet this requirement. But for people, for the quality of adjudication, we need to ensure that merit is not just about how many cases you appeared in, how many cases you argued in. It should also be what is the background you have come from, how much you have struggled to achieve this, what are the difficulties you overcame. Because what we don't forget is that the legal profession has a survivorship bias. I can speak from my own example, and I know so many of my colleagues who, after the first 3 or 4 years in practice, give up practicing in courts because they don't have the networks, they don't have the connections, they don't know how to get cases. And they say, look, they may be at the top of their class, they may be very smart, but they may say, I can't manage this. I would rather go work in a law firm. That means that when, say, the collegium is deciding, we want to appoint X number of people as judges, they're only seeing a certain number of judges before them. 50% of, in fact, more than 50% of my peers in the profession who are women actually prefer to work in a law firm because the hours are better, relatively, there is institutional support, and there is a much more structured way of working. So that means that, our idea of merit, if we are only seeing who is good at arguing cases in court, we will only get a certain kind of person as a judge. So which is why I say that merit and diversity, these are not opposed values. If we want good judges, it has to be drawn from a diverse pool of people. Our high court should reflect the diversity of life experience which people in this country sort of face, and of course keeping in mind a certain minimum threshold of quality in law, integrity, ethics, and so on. That is of course non-negotiable. But I would say that we have to change our understanding of merit to include diversity within it and not see these as two competing values. Mr. Surana, you are back. Now we can hear.
Sorry, I would like the opinion of Mr. Gopalakrishnan, who is the only person in the panel with a non-law background. But as an editor of the National Weekly, I know that he has faced many legal proceedings. Mr. Gopalakrishnan, I would like to know from you your views of what the public thinks about the issue of corruption in judiciary. What are the various images which come to your mind?
Thank you, Mr. Surana. Look, I can't talk much about the higher judiciary because while we have carried stories, I personally have no experience of them. But I spent 35 years in Kerala, so as far as the Kerala High Court is concerned, I mean, all of us knew and all of us firmly believed that there were certain judges who could be influenced and that there were certain lawyers who could adjust the calendar to get a certain judge to hear their case. This was an open secret. There's absolutely no doubt on this. And as journalists and talking to other lawyers, this was totally out in the open. That this is how the system works. So the faith in the High Court was frankly very, very low that it would deliver a fair judgment. Sorry, is somebody else speaking? Okay. There's an echo. I think somebody needs to mute their mic. Anyway, as a journalist, my experience has largely been with the lower courts. We have had so many criminal defamation cases filed against us, and I've had to travel to many places to be present at the court to hear this. And well, nothing ever happened. Every time we went, it was a new date was fixed, and I had to come all the way back saying. In fact, I'm currently facing a case in Bombay. So I had to go last March, and I was let out on bail of 15,000 rupees. So effectively, I'm still out on bail. And the whole process is at the lower judiciary is absolutely biased or against the average litigant. I mean, where do I come in contact with the lawyer? To the local police station and the local court for local issues. I mean, my house, my car gets stolen or whatever. I had, when my house was burgled, I mean, I had to spend so much time in the court to give testimony. I mean, they'd say, come, they'd make me sit for 3 hours and then speak. And I had to go 3-4 times to give the same testimony against the thief. So, you know, it's at these levels that we interact with the law, and it's these levels that we know, we accept. I mean, I've been to Bihar, I've been to UP, I've been to Madhya Pradesh, you know, it's very, very open. I mean, there is a police, there is a judge. So if you have the right contact with the right lawyer and the right cop, you know which judge to go to and what kind of judgment you will get. So it's the lower judiciary is, yeah.
Mr. Gopalakrishnan, we have the pleasure of having in you an actual consumer of justice. Now, you have touched upon an important point. You had to go to the court several times to give the same testimony, which leads us to our next topic, concerns delays in the judicial system. But before we go on to the next topic, I want to ask you a question. If you were to write a report for citizenmatters.in today evening about corruption in judiciary, what will be your headline?
No, my headline would be simply straight. I mean, see, I'll be dead scared of being hauled up for contempt. So, and I don't know what will happen after that. Because we have, when I was editor of the week, this has happened with the Supreme Court once, and they objected to a particular headline, and we had to, you know, fight it out. But fortunately,
I think we lost him. Is he audible? No. Okay.
I think his connection just.
Let's go to the next topic, judicial delays. And here I will quote from a February 2021 report in the Week magazine about Justice Gogoi, when he was asked whether if he would sue Member of Parliament Mahua Mohita from West Bengal. He said he will not approach the country's top court because he would have to endlessly wait for a verdict from what he describes as a ramshackle judiciary. Dr. Justice Jayachandran, how would you respond to Justice Gogoi's statement?
In fact, this judiciary seems to be the last resort of a common man. That's what we keep saying. Unless he has other avenues of getting justice, like before the police station, before going to an MLA or some other politician, as a last resort, after he has failed everywhere else, he seems to be coming to the court of law. It is not easy. Maybe what Justice Gogoi said was right. Maybe many of us would prefer not to go to a court because one is the aspect of delay. You never know. You file a case today and maybe your son or daughter will be handling it. That's the next generation. There are cases, 40% of the cases we are told from statistics that they are 5 years to 20 years old. In fact, I was also sitting heading the criminal bench in the High Court for a while, along with the Justice Nagamuthu. In fact, we had reached almost the final year, which means we have disposed of all the pending criminal appeals till that particular point of time, which was something very, very unusual because we heard that in high courts like Allahabad, the criminal appeals are pending for 20 years. I mean, it's incredible. A person ultimately, if he's found to be not guilty of the offense alleged, what happens to 20 years of his prime life? No, so delay is one main aspect why people fear coming to the courts. Then next is the expense. It is not so easy to, of course, we have the Legal Service Authority, we have some senior counsels doing some free legal aid cases, all those things are there. But then do you get quality justice without paying so much money to the top lawyers? See, this is one aspect. The other aspect is vacancies. At least 1/3 of, let's talk about the High Court. 1/3 of the posts in the High Court across the country are continuously vacant. Say 1,000 plus judges in the High Courts. Now we are told about 640 plus only are filled up. So what happens when 1/3 of the judges' strength in the higher judicial, like the High Court, is vacant for 3 years? That is almost equivalent to closing down the High Court for a full year. So the justice should be it should be inexpensive and swift in nature. So that is one big aspect, because when they say justice delayed, is not only justice denied, it is also justice circumvented, justice mocked at, and the system of justice undermined. So this is.
Pardon my interruption, my lord.
Yes.
He said a few days ago the Supreme Court ordered that the High Courts be allowed to appoint retired judges under Article 224A. In your opinion, what would be the impact on delays by this move?
No, we are not sure, because that has not been tested so far, except I think in 3 cases where it happened long back. In fact, the amount of delay we are talking about is when only 9% of the Indian population had ever stepped into the corridors of the courts. Just imagine, because we are trying to create awareness of their rights through the Legal Service Authority and so on and so forth. Imagine another 10% of the population come to the courts. What will be the state of affairs? So, appointment of ad hoc judges, I don't know how many of them will take it up now. Maybe even if I'm offered, I may not take it up. All right, even if you do take it up, they're going to be given only those old cases. That's what we understand. And only when there's 20% or more of the vacancies are there still existing. So this could be tried. I'm not saying it should not be tried. It could be tried. But how much of a difference it will make for disposing of the pendency of cases, I'm not sure.
I will go to Alok right now. Alok, I would like to ask your opinion. We are now speaking about vacancies and delays in the system. Recently, the law minister in the Rajya Sabha said India has 20.9 judges per million. The UK has 50 judges per million. Canada has 75 judges per million. And United States has 100 judges per million. I'm sorry, I think there is some background noise. I would request other speaker. Yeah, thank you. So one is we have a very low number of judges per million. And the second is, I also know that you have some research and strong views on archaic laws representing the thinking of a bygone era being unsuitable, thereby leading to delays. Alok, please.
So let me just address the 2 points separately. On the first point, in fact, number of judges per million, India has about the right size for the litigation that happens in our population. Let's keep in mind the other critical factor is the GDP of the country, or the per capita wealth of the country, right? The UK and the Canada would need more judges because their citizens have much more wealth overall. More GDP means there is more economic transactions, more civil cases, and so on. Only criminal cases is dependent on the population level. And the Law Commission, in fact, did this research in 2014 and found that, in fact, we can clear out all cases which have been pending for more than 2 years with about 10 to 15%, not even a 10 to 15% increase in the strength of the subordinate judiciary, right? If you first fill up all the vacancies and increase it by about 10 to 15%. Keep in mind, the pendency situation is not the same across every state. it's largely concentrated in about 5 states: UP, Bihar, Gujarat, Maharashtra, and if I'm not mistaken, Madhya Pradesh, if I'm not mistaken. These are 5 states which contribute much more than nearly 50% of all the long pending cases. And in fact, it may need targeted intervention. We don't need to increase number of judges across the board. We may need to work with high courts in 4 or 5 states to improve the justice delivery mechanism. Likewise, I think even with existing capacity, if you improve processes, if you make sure that more technology is used, you will in fact allow judges to dispose far more cases without too much additional stress. One very important element in this is ADR. I don't think we encourage enough ADR in this country. There isn't enough awareness of ADR in this country. If courts, and I'm not just talking about among the people, I'm talking about among courts and lawyers. Among courts and lawyers, unfortunately, beyond a certain elite level, there is not enough awareness of ADR. If we can influence enough people to take up ADR, I think current capacity will be enough to handle civil cases also. Coming to the second larger point that you mentioned, our procedural laws, the Code of Civil Procedure and the Code of Criminal Procedure, are hopelessly outdated. Let me start with the Code of Civil Procedure. Code of Civil Procedure reflects the philosophy of 19th century litigation, is that the basic philosophy is you let the party drive the litigation, which means they can push it however long they want to, they can take how much ever time they want to, do whatever they want to. As long as fairness is maintained, you give both parties a choice, court doesn't intervene. The new philosophy, and this is something that even England has adopted, we adopted this philosophy from England, even England has adopted this philosophy, is that give the judge control of her courtroom. The judge is now in charge of deciding, once you file the case, the matter is out of your hands. It is now in the hands of the judge to say, 1 year, everything will be finished. My judgment will be delivered 1 year from now or 18 months from now, whatever it is. The judge will say, you will file this, and this timeline. If you don't adhere to this timeline, this is the penalty, this is the sanction which will be imposed on you. This is not entirely alien. We have introduced this in the commercial courts legislation. Unfortunately, there have been a lot of subsequent amendments to that legislation, which I don't want to go into, which have supremely diluted a lot of these provisions. But having been part of the process with the Law Commission of India and drafting this law, I can say that this is an effort to change the philosophy of civil litigation in India, that it is no longer driven by the parties, but driven by the judge. Why? Because court time is public time. That is therefore dependent on public money. So it cannot be to the litigant to decide, I will litigate this for 1 year, 2 years, 3 years, 10 years, and so on. Coming to our criminal procedure. Now, our criminal procedure is hopelessly outdated. And you know how hopelessly outdated it is. Look at how poor the conviction rate is. And that conviction rate is poor because nobody is interested in getting a conviction. If that is the case, why can we not change our criminal justice system where there is plea bargaining introduced, where the prosecutor exercises some discretion, should I even bring this case to court, where you shouldn't be operating mechanically. The prosecutor is one of the most important people in the court. Likewise, we can empower the judge, but in the criminal case, we should be empowering the prosecutors to exercise discretion to say, yes, this is a case which is likely to lead to conviction, therefore I will file it. And not just simply because, oh, it has been filed, let us keep moving it. So that's a big change that I want to introduce.
You made some very important points, Alok. Plea bargaining, archaic laws. So let me go straight to Sanjay Pinto. Sanjay, what is your opinion about the delays in courts? Now, I'll give you an example to frame the whole point. I was involved in a case where we successfully got a condoned delay for delay in filing an appeal, and it was 3,000 days, which is almost 9 years, and the court condoned the delay without imposing cost. Another point is there is no cost imposed on frivolous litigation and unnecessary adjournments. So as a practicing lawyer, what do you have to say on this?
Yeah, as a practicing lawyer and also as a legal columnist, I've written 256 weekly legal columns in the Deccan Chronicle, and I've been flagging precisely these issues. The first aspect that you raised, Vinod, about condoned delay, it hinges on the principle of sufficient cause, whether there was sufficient cause to prevent a person from filing their application on time. And several times in court, they say this is a last chance. At some point, that last chance should become a lost chance. but it's never the case. So it's stretched beyond a limit, and that's why you have these adjournments over adjournments. Very interestingly, on the issue of judicial delays, I must point out that recently a Delhi High Court judge made headlines when he said that given the number of vacancies and given the pendency, the backlog, it would take 464 years to clear this backlog. 464 years. All right. Now, Alok spoke about the Law Commission. In fact, I do know that the Law Commission in its 245th report, earlier they had suggested 19 judges per million. And then in 2018, I think a survey was done and it revealed that there were 19 judges for every million. They had Law Commission in the 120th report had said we need 10.5 judges per million. But right now, but in the 245th report, it said you can't just go by the population, but you have to go by socio-economic factors. Now here, if you look at the reasons for this, one, of course, as you rightly said, adjournment over adjournment, sufficient cause. Why don't we, I have a certain recommendation. Why don't we have, instead of having a court vacation, this is a Caroline hangover. Why can't we have a roster system where rotation of judges, where even in the summer vacation, this is a British practice. We can withstand the heat. In the summer vacation, why can't you have a certain number of judges as opposed to just the vacation court actually sitting? That can reduce pendency. Why can't we extend working hours by 1 hour, 1 more hour? That will make a huge difference. I know there are several sitting judges who actually sit beyond 4:45. There are many of them who don't even take a lunch break. I mean, hats off to some of these dedicated judges. Why can't we cap the number of appeals? Just instead of 3 appeals in a civil court, why can't we cap the number of appeals? Why can't we curtail adjournments? Why can't we restrict the time for arguments? For instance, if you look at, again, I go back to the Law Commission report, 230th report, they spoke about a time limit of 1.5 hours for arguments. Today, you have lawyers who argue till thy kingdom come. At the same time, there are those who are shut up even before they open their mouths. So I think the right to a fair hearing, that's very important. There are times when judges just shut them off. The litigants travel from far and wide and then finally find their cases are not even considered. Justice should not only be done, but also be seen to be done. So a right to a fair hearing for a lawyer is extremely important. At the same time, have a time limit. Like in the US, they have a time limit. The buzzer goes off after you exceed a certain time limit. Why can't we have that? Then again, Justice Ganguly had made a very interesting recommendation. Justice A.K. Ganguly, when he spoke about clubbing of cases, identical cases, and he wrote an article in Hansbury Law Monthly, Judicial Reforms, where he said that many cases are filed on similar points. So why can't we club cases? I know even with writ petitions, there are a batch of cases that are filed. Secondly, in terms of, you spoke about also criminal. I'm glad Alok flagged that issue about, the CRPC. This holy grail of 24 hours. Today, we witnessed those horrific custodial deaths in Satankulam. What is this holy grail of 24 hours? Why should it be 24 hours? A lot can happen over 24 hours. Why can't it be less, just 4 or 5 hours, just to produce him before the nearest magistrate? So some of these things, we need in terms of judicial reforms. We need, CCTVs in all police stations. So these are some of the reforms. I'm sorry I took up a lot of time because I was just given a second shot and I was getting messages from my friends saying, why isn't Vinod coming to you? So I thought I'll exhaust all the points that I have.
Thank you, Sanjay. You did cover a lot of points. Yes, this is a very important topic. I am inspired by Professor Rajkumar's mug. He has a galloping horse on it.
I just one more point, if I may make. I know you're not being an Arnab Goswami and me here, but just one little point on judicial delays. Since I'm a consumer activist at heart, recently we had this Consumer Protection Act, the new Act of 2019. Like the old Act, this is meant, the Consumer Protection Act compared to other statutes is meant to be like a Ferrari, but it is worse than a bullock cart. It's a bullock cart that's permanently in the pit stop here, because although the Act provides for 3 months for the resolution of a dispute, 5 months if it requires any analysis, laboratory analysis. On an average, I practice in the National Commission, I practice in the State Commission and in the District Forum. On an average, a single adjournment in the National Commission is 3 to 6 months, sometimes even 1 year. A single adjournment. When I had traveled to Delhi carrying all my clothes, I remember for final arguments in a medical negligence case, the counsel for the complainant very casually said, I was ready to argue, I was all gung-ho. He said, Lordship, I left my bundle in the car. It's raining outside. I said, I brought my clothes from Chennai. I left my bundle in the car. Adjourned by 9 months. What does the Act provide? 3 months. Adjourned by 9 months. I've gone to Delhi for final arguments 6 times. Fortunately, now it's to video conferencing, so I have to travel at Hussein Bolt speed from my bedroom to my chamber here at home. But I'm just saying, these statutes, it's a mockery right now when it comes to judicial delays. It's a mockery, and this is why citizens are beginning to be disenchanted with the system and they are looking at other means. ADR is one thing, but that also is a separate issue for another panel discussion, I guess, where even arbitration can be like a game of snakes and ladders.
Sanjay, you touched upon the cost of going to Delhi and the cost in time, in number of days spent. I will come to that. That is our next topic. But before that, I will go to Professor Raj Kumar. Professor Raj Kumar, I'm inspired by that motif on your mug, a galloping horse. And we are talking of delays in the judicial system. There is a saying that it is important to know the difference between administration of justice and administration of the judicial system. As a law teacher and a dean of the top law school in the country, do you have any course designed for judicial administrators? I know that the 13th Law Commission had in the year 2012, I think it was in the year 2020 or earlier, provided for court managers. What are your views from an academician's point of view? How can we prepare people who can have better administration of justice?
Thank you, Vinod. And I must confess that we don't have such a course, and you probably have given a good idea and for us to consider something like this. And I think such a, at two levels. One is in terms of, in-service training and capacity building programs. I'm not sure whether the National Judicial Academy in Bhopal or other state judicial academies are doing something about it. Because most of the time, even there, I notice, and I've given several lectures at National Judicial Academy Bhopal, and it becomes I would like to make a comment that they should bring a lot more people outside the judiciary to engage with the judges. Most of the time, I have seen that the people who judges are, of course, there in terms of coming from different courts, but the people who talk to them are also judges. So I think there is a case there. But to answer your larger question, listen, I mean, if you look at what, Sanjay has given a series of, suggestions. The irony of reform in our country is that almost every suggestion that we can give here has been given by somebody else and has been documented as well. Not only the ones which has come to Law Commission, when Justice A.P. Shah was there, he led a lot of efforts, but even government's own mechanisms, Supreme Court's own conferences, Ministry of Law's own efforts. You have so much of material out there. But I will confess that there is absolutely no serious political will at one level, and also I would say lack of the judiciary and the legal profession taking responsibility towards this. We have to confess that there is enough vested interest in the legal profession to continue this. I mean, frankly speaking, the one of the reasons why this an unsustainable model of this kind is continues is because of the fact that the key players who are part of the system don't want to change. And so, and I think, I take what Justice Jayachandran said. Mark Galanter wrote a famous article some years ago, and one would think that our courts delays in our courts is happening because that we are a litigious society, but not really. We are not a litigious society. The number of cases that actually go inside the court is, from 10% population. Just that once they go in, they don't come out. They end up staying far too long. And that's the challenge, which is about an internal institutional reform challenge. And I think, Sanjay's frustration with regard to the working of tribunals, even alternative dispute resolution, all those things are very real. So in some ways, it's this program itself, the idea of judicial reforms, we have been discussing at least for the last 3 decades. And frankly, so little has happened. But I do believe that because so little has happened, we should continue to talk about it.
Professor Raj Kumar, if tomorrow you get a call from the Chief Justice of India saying, I would like you to give me 2 points which I could implement at the National Judicial Academy, what could be those 2 points?
Great, wonderful. So I think the first and most important aspect of this is, and this is, by the way, already begun. Justice Chandrachud is heading that even before the global pandemic. Use of technology in administration of justice in a very significant manner. And I'm here not talking about high courts. And after all, we are a country which is aspiring to be part of the global engagement. And I don't see any reason why every court in India, the lowest court, is not fully equipped with technology. And seriously examining to what extent, like Alok mentioned, Justice Ganguly's suggestion. Now, I think there is a serious way by which these things could be done if we begin to use technology. For example, across different high courts, are there similar cases coming up with issues that are coming forward? There should be, today we are talking about, I think Vidhi Center recently did a conference focusing on artificial intelligence and to what extent AI can be brought into the administration of justice. So in a way, the first and foremost thing is we need to understand to what extent this can be used for the problem that we are trying to solve. The second thing is, I do believe that there cannot be any excuse for the judiciary not putting its foot down for completing the appointment process. I mean, one should not underestimate that. I hear what Alok and others are saying about population percentage versus judges. But there's something fundamentally wrong if 30% of judges in the High Courts and Supreme Court is lying vacant. There is a latent effect to it, because it's not just the fact that 30% of judges are simply not present. And once you go down the lower court, I mean, frankly speaking, I was told, I don't know, but apparently the last Chief Justice of India could not appoint a single judge to the Supreme Court. And those are serious matters. And we know that a previous Chief Justice of India was in tears that he was not able to do much. So the point is, we really need to, you asked a very good hypothetical question. I think most of the problems are actually with the judiciary, and judiciary needs to take responsibility for it. And it has to put its foot down and be stronger. And that connects to the problem of, potential favors and future appointments, and to what extent they are not, independent. All those things are connected to it. But from where I stand, this is a problem that can be addressed if the judiciary wants to. And it's time we do it, because, as Sanjay says, people are slowly losing faith. And somebody said quite sarcastically, and I hope it is not true, that Indians are very smart. They don't want to go to the judiciary if they actually want to solve a problem. They actually want to go to the judiciary if they don't want to solve the problem, because there are other ways to solve the problem outside the legal framework. And I hope it is not true, because when you, and we see this in so many matters, to get a stay order, to actually delay the process, so people they've started to abuse the entire justice delivery mechanism, and that will be death knell to the rule of law.
Raj, you have made some very, very important observations. The judiciary must take responsibility for its act. Now, I know as lawyers and as academicians, we will try to do our best. My next question is to Mr. Gopalakrishnan, who represents the fourth estate, the press. Mr. Gopalakrishnan, what is it that the press can do? And what is it that the press has done to improve the functioning of the courts? And let me assure you that you will not get a contempt notice.
No, it is not the press's job to improve the judiciary or bring about judicial reform. We talk about it. I mean, when experts like you write, we publish it. We disseminate the information that various expert committees and experts have said should happen. But the role of the media is only that, disseminating information. No, we cannot run, media should not be running a campaign saying, bring about judicial reforms. I mean, I don't think that is the role of the media, but pointing out these issues, getting views of experts, disseminating, creating awareness amongst our readers, and that is the way I looked at it as my primary function as editor. I mean, I'm not running a campaign thing. Let me give you a very simple example. I mean, we did a series of stories on Section 360, that is the rape law, after that famous case in Delhi. And there are, you won't know, I mean, then there are umpteen Supreme Court judgments, verdicts on how the police should conduct investigation in a rape case. And, in fact, one of the points made was the statement of the victim is to be taken on face value. You cannot question her or cross-examine her. Now, in Delhi or in Bangalore or Cochin, fine. I mean, the courts and the police know this, but go 10 kilometers outside Delhi into Haryana, into Faridabad, not one policeman knows a single Supreme Court directive on how to investigate a rape case. I mean, all this talk about this Hathras rape case and all that. See, High Court and Supreme Court, I don't know. I mean, that's higher judiciary, but as a reporter and as a journalist, my experience has been in places like Hathras, in places like Darbhanga and Bihar, in Siliguri. I mean, there's no question of a villager getting justice. I mean, this is either you pay money to somebody via your connections, or it is politically decided that we are going to hit out at these people. Period. There's no other law involved here. There's no legal issue involved here. So it's the media, we highlight this. I mean, the Nirbhaya case in Delhi, if it wasn't for the media storm, I doubt if the Nirbhaya Act would have even been considered. Similarly, there was the Banwari Devi case about 30 years ago. Hathras wouldn't have become such a big issue if it wasn't for the media highlighting it and again bringing out the lacuna in investigation. The biggest issue here is investigation. And of course, the judges granting stay after stay after stay. I mean, there's this case in Chennai, I think, where the lower court convicted the person and the appeal is pending with the High Court for 2 years. I mean, the law states that these cases should be disposed of in 1 year.
Sanjay Pinto has raised this hand. A quick point, Sanjay, before I go back to Professor Rajkumar on the role of media.
I'm glad, my veteran journalist friend, Mr. Gopalakrishnan, has raised that issue. Recently, remember, there was a furor in the country after a High Court judge at the Nagpur bench of the Mumbai High Court had come up with this ridiculous, outrageous, no skin-to-skin contact. Now, that back to what Alok had said earlier in terms of these laws, even in a relatively new enactment like the POXO Act, it is shocking that the term physical contact has been defined. Physical contact. And then they say, go back to the IT Act, go back to several other legislations. There too, it's not. So therefore, it is left to the subjective, interpretation of a judge. So these are some of these shocking cases when it comes to sexual crimes. I wanted to just, as an aside, I wanted to mention that.
I want to speak to Professor Rajkumar, not as a law teacher, but as a vice chancellor of a university which has a very reputed school of journalism and public policy. Professor Dr. Rajkumar, as a vice chancellor of such a university, what is your view? How can the media, the court estate play a role in judicial reform? May I request Mr. Gopalakrishnan to mute his mic?
No, I just wanted to make.
Mr. Gopalakrishnan wants to speak, so let's unmute yourself, sir.
I'd just like to bring to your notice what has happened in the recent West Bengal election campaign. I mean, there is a ruling by the court against a set of media publications. A few candidates went to the court saying that the news reports against them have been negative. So the court has issued an injunction on these. I think there are half a dozen media organizations against publishing any report about these 5 or 6 candidates. Now, this is, when you gag the media in this manner, when the judge gags the media in this manner, and without going into merits of what were the reports that were published. I mean, these candidates went to court and the court just issued an order saying you can't publish any more items. Now, I mean, the right to free expression, the freedom of press, blah, 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 everything goes for a 6. So, the role of media in exposing, saying how many of your candidates have criminal antecedents, if that cannot be published, and that too because of a ruling by the High Court, then where do we go? Where does the media go? I just wanted to highlight this point. Thank you.
Okay. All right. Thank you so much, Vinod. Listen, Vinod, we have to recognize that. I consider myself as a World This Week generation person. I grew up watching World This Week, and I consider many aspects of Indian media to be playing a very important role. But the reality today, unfortunately, is that media has come to a large extent away from one of the most fundamental principles of journalistic ethics, which is about speaking truth to power. And that notion of speaking truth to power has been replaced with all kinds of agendas, not necessarily only confined to the obvious ones of paid news and advertisements and essentially favoring different organizations and parties and things like that, but something much more deeper is inflicted in many aspects of our journalistic profession, which is about the fact that no longer a good part of the media is actually focusing on the notion of truth and its ability to address power holders in all form. And unfortunately, the 24/7 TV channels have gone in a very different direction, which I think affects the ability of justice delivery mechanism. I mean, reputations of people are tarnished overnight with no effort to correct it. Absolute irresponsibility of primetime anchors to say whatever they like in the name of freedom of speech and expression, including media freedom. Little or no accountability whatsoever, even when truth comes out later. So in a way, we have to do soul searching there as well. I mean, the reality is the strength of any democracy is the ability of all its institutions to exercise responsibility. There's a reason why media has been given the title of a fourth estate. And frankly speaking, it should be a fourth estate and not a real estate space for anybody to buy on sale. And I think that role of the fourth estate needs to be cultivated. And so one of the things that we are attempting to do in our Jindal School of Journalism and Communication is to impress upon the need for ethics in their behavior. But frankly speaking, role models in society are not too many. Role models, even in the media as a profession, are not too many. And so I go back to that point where we cannot expect young people to develop a world of idealism in a society that does not regard idealism as value to be pursued or to be celebrated. And hence, it becomes important for all of us to be very conscious about our own behavior and our own conduct, because that's what is going to shape the minds of young people.
Rajkumar, you made some very, very important point. I'm sorry, we are running over time. I will not be able to come back to you on those. But you said media is the fourth estate and not a piece of real estate. We have two more important topics to cover. One is judicial overreach, and the other is use of technology in judicial reforms and access to justice. In the constitutional scheme of things, the balance of power is central in a democracy. I quote Honorable Jemmy Wright, Queen's Counsel and Member of Parliament in the UK, who says, there are constitutional and practical reasons why it is not necessarily courts that are best placed to take decisions involving matters of public interest. In my view, there are circumstances where it is clearly right that decisions on matters of public interest should be taken by an elected, accountable politician rather than a court. 3 days ago, we saw the Supreme Court passing an order asking for a national crisis plan. The Supreme Court has set up a committee to review and supervise the working of the Board of Control for Cricket. We have the Supreme Court set up a committee to review farm laws. We have every High Court in the state at least once in 15 days making sure that the Chief Secretary of the government of the local state appears before the court in some contempt proceedings. So I would like to now request the views of Justice Dr. Jayachandran. What are your views, sir, on judicial overreach? Is there anything called judicial overreach, or is it just pure and simple judicial activism to protect democracy?
See, we find judicial activism, judicial restraint, and judicial romanticism, trying to be very popular, passing certain orders. See, all these aspects are there. Judicial overreach is when that what you call as the Lakshman Rekha is crossed by the courts of law, because the division of powers very clearly states that the executive, legislature, and the judiciary should be operating in their own fields. But we find due to over enthusiasm, there are n number of cases. Even I could quote. In fact, I gave a full speech on this judicial overreach some time ago. In one case, which I found it to be interesting to quote at this juncture, in New Zealand, there was a river called Te Awa Tupura. I don't know whether I'm pronouncing it right, but this was a river which the Maori tribes there regarded as really sacred and spiritual in nature. So the local government, after nearly 170 years of the issue being raised by the Maori tribes and a whole lot of vegetation, things like that, the local government, the New Zealand government, had recognized it to be something like a human being having certain rights. A week or 10 days after that, the judges in Uttarakhand High Court had read that, they suddenly declared rivers Ganga and Yamuna to also have similar rights. Imagine, without, then they appointed three persons like advocates to monitor and trying to clean up Ganga and Yamuna, which from statistics, the river, it gets about 1.5 billion liters of untreated sewage and about 500 million liters of industrial waste per day, Ganga, for example. Now, this is after the central government had appointed, I think, a part of the ministry to take care of these two rivers. So is this like this? There are a number of instances where the ban on liquor shops in these highways. Even here in Tamil Nadu, we had this removal of this Seema Karuvel trees, which were growing all over the place. I can quote n number of cases where the judiciary ought to have restrained itself and not step into the jurisdiction of passing certain orders, which, first of all, many of these orders cannot be implemented. You should be passing implementable orders. So this I think is as it is said, we should not be like a bull in a china shop or an elephant in a haystack. We restrain ourselves to do what is to be what is expected to be done by the judiciary, basically. So I think this overreach is sometimes, in fact, Supreme Court itself has admitted when it gave certain directions to the CBI and things like that, when the other wings of the government fail, we step in. But often enough, they do overreach, cross the Lakshman Rekha, and that is not the right way to go about things.
I have a question for Alok. As a think tank, when we are seeing the Supreme Court and the various high courts set up so many committees to look after everything, from pollution of rivers, to the state of cricket administration, to distributing food grains available in the godowns of the Food Corporation of India, to monitoring pollution and things like that. Now, you made a statement earlier in this session that if we have judges from diverse backgrounds, they will be able to better understand the problems. So what is your opinion, Alok?
On this topic of judicial overreach, there is a fantastic book called Courting the People by one Anuj Bhuvania, who is a professor in, I think in Jindal. I think Mr. Dr. Rajkumar should know him. He is now with Jindal, and his book is fantastic because what his argument that he makes is that the failing of PIL wasn't the topics that they chose to intervene in. The problem with PIL was how they made procedure an enemy. Procedure is your friend in courts. Procedure ensures natural justice. Procedure ensures fairness and transparency and all of that. But by making procedure the enemy of outcomes, what meant is that the outcomes themselves would start to become bad. It meant that judges would order demolish these slums, close down these factories, remove these tenements, and these are, at the end of the day, whose rights are you protecting? Courts are supposed to protect people's rights. Are you giving these people an opportunity to be heard? Are you giving them an opportunity to present their case before you? You said, oh, procedure is all waste. We don't need to hear them. So this is a fantastic book, and I'd urge everyone to please read this. And I would like to draw upon that to say that, see, committees don't do anything. Somebody sort of very pithily said a committee just means come to tea. And that essentially what ends up happening. Committees can't run anything. Committees cannot give you any solid suggestions and so on. At most, a committee of well-chosen experts might give you suggestions, but they can't take the decisions. And unfortunately, our courts don't seem to be, learning their lessons from the past. I can give you a recent example. It's a live example. There was a recent case of a so-called encounter killing in Uttar Pradesh, and somebody filed a case in the Supreme Court. The Supreme Court put it before a committee, an inquiry committee, and that inquiry committee, it's been headed by a very well-known retired Supreme Court judge, but the composition of the committee did not inspire confidence in a single witness to come and depose before that committee. This is a proper judicial function. I'm sure the Supreme Court is worried about encounter killings. Say we will designate this court as the court in charge of examining this case, holding a proper inquiry. All provisions of CRPC, flawed they may be, they will apply before that court. Follow that procedure. People will feel confident to say, okay, when I'm giving, okay, that person may be acquitted, convicted, whatever may happen to them at the end. I feel like there's proper judicial procedure taking place, and I will follow that. What the Supreme Court is in, and unfortunately happened because of this kind of adjudication by committee, is that the court's own credibility is getting affected. As a cricket fan, a cricket fan in me appreciated, oh, finally somebody's holding these BCCI fellows to account. But the lawyer in me felt, what is the Supreme Court doing? In 2 years, the Supreme Court lost its, Supreme Court lost its interest in its case, and now BCCI is very freely flouting most of these directions. So what hurts, of course, is BCCI is doing whatever it wants, but now the Supreme Court is looking like it wasted its and everyone's time in the process.
You said procedure, which is a friend, is made an enemy of the outcomes. Very powerful observation. I am repeating this. So one, I internalize it, and two, when I write about today's webinar, I will be quoting these points. Let me ask the lawyer, Sanjay Pinto. Sanjay, if you were called by the Chief Justice of the Madras High Court to say, please be a member of this committee to look into, let us say, pollution in the river Kaveri, or the farm laws being implemented, and give the suggestion, what will be the first thoughts which come to your mind, and how will you respond? Will you take it up?
Most definitely. Since I've been advocating judicial reforms from the time I was a school student, since the time I was 13, I've been writing in newspapers, and I was just entered my teens. Very coincidentally, just a couple of days ago, Vinod, the Honorable Chief Justice of the Madras High Court, Justice Ajit Banerjee, spoke about the Coombe pollution. He said he himself had witnessed that even with that high wall, you could get the stench. Even while passing through the Napier Bridge with the air conditioning on, you could get the stench. So I have a slightly different view from Alok and Justice J. Chandran with the greatest of respect. I, for one, believe that the doctrine of separation of powers need not be written in stone. When there is a vacuum, the other different estates of democracy fill in. A student had once told me very, in a very witty fashion, when there is no GO, there's an NGO. Meaning when there is no governmental action, that's when an NGO comes in. And these NGOs are, just force multipliers. They rely on courts, which is why I think it's very important that the line of the constitutional LOC, as it were, can be redrawn sometimes in public interest. Now I find that this concept of public interest, a lot of people style them as publicity interest litigation. I for one wonder, why demonize publicity? What is so wrong about publicity? If somebody wants to bring up a good cause, don't grudge him his 15 seconds of fame. Why demonize publicity? Publicity is something that there is no law that bans publicity. If somebody wants to bring up a good cause, and if you feel that it's only for publicity, there is a vexatious litigants act in certain states, why can't then the judges, then hearing that matter, put a gag order and say, oh, okay, we don't trust the bona fides of this particular litigant. Don't report it. Don't report it. But why impose cost on that? Because a grievance is the most intense form of expression. And if a court that is supposed to actually uphold this freedom of speech and expression, not a granted but a guaranteed right of or a guaranteed fundamental right, there can be no more greater chilling effect on freedom of expression if the court were to impose costs just because they feel that somebody's PIL is publicity oriented.
Hello, you have. Yeah, go ahead. Unmute, please.
So I just to clarify one point, I agree that separation of powers is not cast in stone. My only issue is the idea that judges can act as if they are the legislature. They can't. They should follow certain procedures which, sort of make the judiciary work as a judiciary. It shouldn't become a total legislature. That's the first point that I want to make. Second point, I'm not using any names, obviously, but I'll give you an anecdote I was personally privy to. A newspaper reported on the shady dealings of a famous politician. And this politician was well known. No criminal action was, because in that particular government, he was in power. So no criminal action was immediately taken, but they feared somebody might go to the High Court and file a PIL and say take action against him. So what this politician did was he went to one of these publicity-seeking PIL persons. Like, this is a person who every other day is filing a PIL or something or the other. Says, you file on Farzi PIL, it'll get dismissed. Tomorrow I will say res judicata next time somebody tries to file a genuine PIL. And that's what exactly happened. He paid this person to file a completely Farzi PIL, asking for investigation against this politician. No particulars given, no details given. Court said, what is this? This is rubbish. We can't pass orders, and dismissed it. Next day, sure enough, all the newspapers carried the information. High Court dismisses PIL against so-and-so politicians, illegal dealings. So, I mean, when you say publicity interest litigation, the nicest thing about it is the publicity.
I have Alok and Sanjay have pointed out something very important, and this takes me to a question to Dr. Justice Jayachandran. You told that when there is a vacuum, there is no harm in the other wing of the government stepping in to fulfill the vacuum. Now, my question to Dr. Justice Jayachandran is, from the record, it is seen that the courts have not filled the vacancies for decades. We have had 30% plus vacancies for decades. So will the courts accept if the executive steps in to fill this vacancy? What would you think about it?
No, when I said, I mean, I never meant that there should not be public interest litigations. Publicity, populist orders, I meant it's for the judges, not those who are filing cases. We should not, there are, I mean, I don't want to quote specific instances, but there are cases which the judges have, decided and passed very unusual orders. Sometimes, we find it to be very unusual. So therefore, I meant not publicity for those who are filing cases. Of course, the courts are there to see to it that it is not just publicity oriented, and it is really a public interest litigation. And as we said, the Lakshman Rekha should not be crossed by either those who are filing cases or by the courts. It should have certain self-restraint, and in each individual case that has to be decided by the judge concerned. But in fact, when our names had been, at that stage, I think, you must be knowing when 17 of our names had been sent up to the the government, the executive, there was a public interest litigation filed by Mr. Arvind Dattar before the Supreme Court, because it got delayed by 1.5 years or so. After names had been sent to the government, central government, it was kept pending. No, it is the other way around. It is not that the executive will step in to fill up these vacancies, because now it's very clear that the ultimate deciding factor will be the Supreme Court, and then which recommends it to the president ultimately. So the government's role here is not as important as that of the judiciary. I mean, that's how the judiciary has decided in a series of cases. So stepping in by the executive does not arise. So maybe if there is a delay, the Supreme Court can give a direction to the executive to. But now each one, the Supreme Court is blaming the executive, and the executive is blaming the Supreme Court or the High Court, saying you're not sending names in time. So I think ultimately this has to be resolved for the benefit of the judiciary.
Pardon my interruption, my lord.
Yes.
My lord, pardon my interruption. My question was, Alok and Sanjay Pinto made a statement that the division of line of powers, the line is not sacrosanct. If one wing does not fulfill its duty, the other can step in. So how will the judiciary respond if the executive steps into any place where the judiciary has not fulfilled its role or is found lacking? Who will judge?
Judiciary will definitely rule it down, saying the executive business to step in here. Of course, you see, as I said, the Supreme Court itself has admitted that yes, we are crossing the Lakshmana Rekha at times when the other wings had failed. This is, of course, in the perception of the judiciary itself, by the Supreme Court itself. So, therefore, ultimately, I think the judicial decision will prevail. Whether the executive, they try to impose themselves on the judiciary by filling up these vacancies by one way or the other, I'm sure the courts will strike it down. That's how.
We have overrun our time, so I would like to close this in 10 minutes. Let us quickly go to the last topic, which is access to the application of technology in judicial reforms, bringing in transparency. But before that, just a point to consider that one of your faculty members, who is named Varia, has written a very good book on judicial activism. So maybe you can make this as one of the readings for your School of Journalism. And congratulations to the professor from your university. So now let us go to the concept of technology and judicial reform. Alok, I know Professor Rajkumar has just mentioned that you did a seminar on this topic. Viti Center has published recently a paper on artificial intelligence and judiciary. Our past Chief Justice, Justice Bobde, has mentioned 1.5 years ago in a public speech in the Supreme Court Bar Association that the judiciary looks at artificial intelligence to solve a lot of problems. So what is your take on technology and artificial intelligence in judicial reforms? Unmute, please.
One of the good things about the Indian judiciary is that so much data is generated every day. It makes it very suitable for training artificial intelligence. See, artificial intelligence depends on how good the data that generated is. And a lot of people that I know who work in the AI sector have relied on judicial records, data, and so on to train their models for various reasons. You can train judgments, all of that. People are of the misconception that using AI means you replace judges with AI. That's not true. One use case, which I think has the most actually two use cases. One is, which we mentioned much earlier in this discussion, and I think Mr. Sanjay Pinto mentioned this, clubbing of cases with similar similar questions of law. Now we are relying very much on the registry staff to understand the question of law and put cases together. AI should, when you file it, it should be able to scan the pleadings and say, identical question of law pending before this honorable court, before Justice so-and-so, placed before Justice so-and-so. It shouldn't even depend on registry staff. This is one important use case. You'll be able to club hundreds of cases together. And I see it especially in the context of land acquisition, Section 138 and NI Act, what do you call, service laws, income tax laws. The possibilities are enormous. The second big use of AI that I think is that one of the problems, and we mentioned this earlier in our discussion also, is that criminal appeals in high courts are horribly delayed. And one of the reasons for such delay is that not enough quality lawyers and judges tend to be available to dispose of criminal appeals. Criminal appeals are not very easy to dispose of, especially if it is a capital offense, especially if it involves a conspiracy where 20, 30 people are involved and each one has a different involvement. And I remember this because this happened when I was practicing in the Supreme Court. The first time the Supreme Court actually used e-court was not during the pandemic. It was in handling the Bombay blasts case. When Justices Chauhan and Justice Sadasivam, they actually heard this case mostly using digitized material because the actual records of the case had to be stored in trucks. It was so huge. Just the records that one case had to be stored in trucks. So what AI can do is read a record this thick and say, these are the undisputed facts. This is the statement made by A1, A2, A3, so on and so forth. Sorry, this is the involvement of A1, A2, A3, and so on and so forth. These are what the various prosecution witnesses have said. These are what the various defense witnesses have said. The judge doesn't have to go page by page. The lawyer doesn't have to say, my lord may read this, my lord may read that. All of it should be available on an easy interface for the judge based on AI reading the material and understanding it and making the judge's life simple. So much time could be saved immediately.
Okay, I have a question for Sanjay Pinto, the law practitioner. Justice Chandrachud, who is heading the E Committee of the Supreme Court, made a remark. He really wants to bring in technology, the judicial process, but he made a remark saying there is a strong pushback from the senior advocates and established players at the bar who are not comfortable with the transparency which online hearings bring. They cannot get away with saying something and then denying it. They cannot make bombastic statements. They are under scrutiny which they are not used to. What is your take on it?
I think school children have adapted to online education. There's no reason why lawyers should not adapt to online hearing of cases. That said, there's a very real issue of connectivity, internet penetration, whether several lawyers, especially in the Mofussil areas, whether they're really acclimatized to the online system of functioning, whether many of them have high-speed data, whether they have laptops. So these are real issues. We need to sort them out. But Justice Chandrachud also in this context had mentioned very recently, he in fact lamented, over the cut copy paste syndrome when it comes to writing judgments. Another brother judge in the Supreme Court said that he has to use tiger balm to read some of the judgments the way they are written, especially in the high courts. So I think this is, in fact, let me give you a small example. Justice Sivanyana, who's in charge of the E Committee here in the Madras High Court, I had written a column. In one of my columns, I had flagged this issue of mentioning, which is like we give very chaotic, especially in the online mode. And I had suggested that we have a separate list for mentioning, because for mentioning right now in the Madras High Court, you're supposed to send a mail to the registry in advance explaining the urgency before 9:30 that particular morning, 1 hour before the court starts. And then they decide whether you are allowed, the bench clerk will decide whether you can make that mention or not. So I had suggested you have a separate list for mentioning, which you can draw quickly 1 hour before the start. And they had implemented it. So which means there are some good suggestions which our honorable courts are taking note of, because this is an evolving field. I think this really is the future. Sitting here in Chennai, I'm able to do arbitrations in Mumbai and Pune and several other places. This is a boon, but this is perhaps just in its early nascent stage. We'll have to give it some time. But I think we should have an open mind as far as technology and the judiciary is concerned. It can save us a lot of time.
Professor Rajkumar, you are not only an academician, but I also look at you as a social thinker who is able to crystal ball gaze into the future. As also the dean of the top law school in the country, how do you see technology getting into the entire judicial process, the access to the justice process?
Thank you so much, Vinod. But before I answer that question, I want to quickly say that the heart of what we are discussing today with regard to judicial reforms, as well as the quality of the legal profession and judges, one aspect which we didn't cover adequately, and I think I want to say that is, we really need to focus on the reform of legal education. The reality is we have 1,650 law schools in India. We are graduating over 75,000 law students every year. And the fact is, these graduates who end up becoming part of the legal profession, and we have in that process created, even the chairman of the Bar Council of India famously observed a couple of years ago that, over half of the law schools need to be closed down. And even he talked about fake lawyers and all of that. So the point I'm trying to say is that a lot of these things that we are talking about, its foundation is the quality of law schools and legal education. And I would like to blame to a large extent the judiciary and the legal profession, who have unfortunately given scant regard to the need for improving the quality of legal education. Of course, I will blame the academics ourselves, because we have ourselves failed in our duty and responsibility. But I think the larger context of this responsibility need to be taken, because everything that we talk today with regard to the reforms, we can do a lot more when it comes to improving the standards of legal education. As far as technology is concerned, I do believe that this is this black swan moment that we have.
I will interrupt for a minute before letting you just continue, but something struck me very strongly. Have you consciously avoided blaming the Bar Council, who is the main player? Why have you singled them out by not naming them and blaming them?
No, I will tell you what. The reason I'm conscious about not blaming any particular institution as opposed to individuals connected is because, after all, the Bar Council represents a legal profession. So when I say lawyers, for example, I'll give you a simple example. Now you are part of a law firm. Now you are a unique law firm because you have, for the last, at least I have known you for over 3 decades, you have taken enormous effort to engage with law schools. You connect with students beyond your objective of recruiting law graduates. But if you look at every law firm without exception, the only reason they are connected with law schools is to recruit good lawyers. The point I'm trying to say is that the legal profession and the judicial fraternity in general need to take greater responsibility when it comes to improving the quality of legal education, which has a direct and substantive link with regard to the future of legal profession and indeed the judiciary. And in that context, Bar Council including, because they are, after all, lawyers who end up getting elected to the Bar Council of India. As far as the second question about the main question that you asked me was, I do believe that technology is a very compelling, opportunity. Although I must say that it's very important. It is easy for us to move away from what we are doing soon after the pandemic. I do fear, and I've had discussions with Honorable Justice Chandrachud on that matter as well. And the point, I think it's important to create a culture, and a cultural and attitudinal shift needs to happen. But this cultural and attitudinal shift, unfortunately, cannot happen only to the privileged few. And I consider myself as a privileged institution. And I must say that the lawyers and the judges who are present here are also part of privileged situations. The real challenge for use of technology is it should not be, again, a tool for the rich and the well-off and the more the affordable people accessing lawyers who use technology and engage in these forums, and the ones who simply don't have access are completely cut out of it. So the democratization of technology is the most important thing. So I will say that if before even we focusing on the high courts and the Supreme Court for technology, we need to inbuild capacity in our lower courts, in our district courts, in the courts that are present across the country. And once you change the situation there, once you empower the lawyers and judges there, the change will happen much faster, because then it will become almost inevitable and the ones at the top will change.
I would like to go on and on because this is such an important topic, but all good things have to come to an end. We have overshot our time by almost 50 minutes. The enthusiasm of each panelist is very infectious. I wish I could go on, but I think we have to come to a close. So before we close, I would like to ask each panelist one sentence on judicial reforms, which comes to your mind straight away. I will start with Honorable Justice Jayachandran. You have to unmute, sir.
The topic you have chosen for today's webinar is really appropriate. I feel there should be a 360-degree reform in the entire judicial process. We cannot be sitting on ivory towers and keep hearing fairy tales of yore. We have to put our ears to the ground and see the rumbling of the thunder, far away thunder, so that right now the gloss, the glamour, and the glitter of the judicial system is fast waning. So let us all together equip ourselves to handle the increasing demands for quick and quality justice before it is too late.
Thank you, my lord. Alok, the think tank.
So let me make one statement on judicial reforms, and this has to do with the how. Let's not wait for political will. Let's not wait for trying to reform. I think there are enough small changes that are possible at the High Court district level. Make those changes, show that they work, and then scale it up. Because I don't think we're going to get anywhere if we're going to try and reform the system top down. If we have to make judicial reform, starts at the lowest level. And if you ask me, if we fix all the major issues at the level that most people access courts, which is your magistrate and civil judge level, I believe we'll have done a massive change in judicial reform, even if we don't touch a single thing about the High Court and the Supreme Court.
Thank you. Our friend from the Fourth Estate, Mr. Gopalakrishnan.
I agree with what was said. You need to do something at the lower level to enable access to everybody. I think right now, access to justice, to the law, is severely limited to those who can afford it, to the village panchayat head, to the rich landlord, but nobody else, the average villager, has absolutely no access to them. I think the priority is to allow that access, however it is done.
Thank you. The point is taken, and I hope you will write in citizenmatters.in about judicial reforms, about the various points we made to create a groundswell of support. Now let me speak to the practitioner, Sanjay Pinto. What is that one point you would like to leave us with at the end of this webinar?
In a sentence, even had a justice for the dissenters and for the A-listers. For the Stan Swami, you needed a sipper in prison, and for my good friend Arnab Goswami, you needed bail. Even-handed justice for all sections of society.
You said a lot in that one sentence. Vice Chancellor Professor Dr. Rajkumar, what is that one thought you would like to leave us with?
Well, the most important thing for the judiciary, I believe, is that a serious introspection and a recognition that a judiciary cannot solve all problems of society and other institutions need to be empowered. And that empowerment can happen only if judiciary defers to other institutions for certain actions. And even at times, if it had the provocation to intervene, it should resist from it.
Thank you very much. That was a last ball 6. Thank you very much. I am very, very grateful to our partner academic institution, the Jindal University, to its dynamic Vice Chancellor, to Dr. Pankaj Gupta, the head of the Office of Career Services, to Mr. Gaurav Shukla from the Office of Career Services, our other esteemed panelists, Mr. Gopalakrishnan, the editor of citizenmatters.in, Mr. Alok, who is the co-founder of the Vidhi Center for Legal Policy, Mr. Sanjay Pinto, the practitioner and columnist and author, and of course, Dr. Justice Jayachandran, who is an inspiration for us. He did his PhD after retirement. Thank you all very much. Thank you very much.
Thank you, sir.
Thank you. It was my pleasure to be on this panel. Thank you.
Pankaj,
Thank you very much, all
Yes.
of you.
Okay,
Pankaj,
thank
you're
you.
supposed to deliver the vote of thanks.
Yeah. Sir, thank you so much. And it was really a great session. And I'd like to thank all of you. Surana ji for his very excellent leadership and, leading the panel in such a very great manner. And we could hardly see that it has been over 52 minutes extra. And everybody got so engaged. So my deepest thanks to you, Surana ji, for this. And our beloved Vice Chancellor, Professor C. Kumar, for his keynote address. And also he shared about some very important thing about transparency, diversity, building the competence, integrity. And towards the end, he shared also about the introspection. And also very important point about the democratization of the technology part. So very, very important point. So thank you so much, sir, for that. And Honorable Justice Jayachandran ji has given so many very important insights, and from very, very practical perspective we have shared. And also his commitment towards creating the speedy justice, and his point was very correct when he shared that sometimes the justice delayed is also like a justice denied. And Sanjay Pintoji has also shared some very, very important insights from a practical perspective, and also his great experience has been very much appreciated, sharing that. And so was with Alok Prasanna Kumar ji, where he shared about very important insight about the overreach, and also about the delay in the judiciary. And so was about the media, Mr. T.R. Gopalakrishnan ji has shared some very, very important insights. So I would like to thank each one of you. And one of the very important point which Surana ji had started about the corruption. So I'm happy to inform you that our Honorable Vice Chancellor has been giving us a lot of very important insights. He has been always leading from the front. And I believe that his passion in getting things done, because sometimes the values are not taught, they are caught. When you see your leader doing so many things and telling you the thing about passion, forgiving, moving on, so those things you imbibe without you being told anything. So I want to thank him so much for that. And also we have created a center for mindfulness, spirituality, and ancient wisdom, where we are also discussing about that, not about the doing part. One is that you do something and you have something. Another thing is how you be something, because the being will lead to the right doing, and the right doing will lead to right having. So we also have a very good seminar series where a lot of very ethical leaders come and they share their insights. And one of that person, we had invited Justice Tevatia. He had made one very important remark. Now he is no more, but we had very long association with him. He used to say that even the judiciary also, there may be ducks and there may be eagles. Then he said the people, the judges who are the eagles, they have no past and they have no future. So he said that when your past is clear and you have no desire that I will become so and so chairman, I will become so and so, then you can always handle your responsibilities with a lot of fearlessness. So in this way, a lot of very important insights are there. So we will try to summarize the whole paper in a transcript, and we'll be sharing with all the panel members. And in this way, I'd like to thank once again all of you for your very excellent contribution. So, and also, Surana ji, I'd like to say that we should go on with one more edition, because this topic is so important. We should also create some sort of an action plan, and with the support and guidance from our Honorable Vice Chancellor, we'd like to take it forward. And once again, I would like to thank all my very important member of my team, especially Gaurav, Anubhav, and all my OCS team. So a big thank you to all of you. And namaskar. Thank you so much. Really.
Thank you.
Thank you, and bye-bye.